Okay, well, thank you, and thanks very much for the invitation. For the past couple of years, I've been working on the international legal framework regulating humanitarian relief operations in situations of armed conflict. And I thought it might be interesting today to have a bit of a conversation about the interplay between counter-terrorism measures and humanitarian action, which is an area that a number of humanitarian actors operating in situations where non-state armed groups are controlling territory or access to civilians have had to deal with. But interestingly, apart from those people who've really focused on those areas, hasn't received so much attention. So what's the issue? In a number of conflicts today, there are non-state armed groups or parties to the conflict that control territory of civilians, and often there are civilians in need of assistance in those areas. In responding to them, humanitarian actors face numerous challenges, including the usual ones of insecurity due to lack of facilities or a breakdown in law and order, or bureaucratic constraints imposed by parties to conflict. However, in recent years, they have faced new challenges, an additional hurdle. Sanctions, but also counter-terrorism measures, requiring states to ensure that funds and other assets do not benefit directly or indirectly groups designated under these instruments, are impairing their operations. Frequently, the same groups that are parties to the conflict, that control territory, have also been designated under these counter-terrorism measures. And the prohibitions that we see are on providing support to these groups are extremely broad and can potentially include relief supplies that are diverted by these groups or that otherwise benefit them, payments that humanitarians have to make in order to be able to operate, in order to transit through territory controlled by these groups, but also has a more extreme range of the spectrum. The provision of medical assistance to sick members of these groups could amount to unauthorized support, and violations of these prohibitions are criminalized. These measures significantly affect humanitarians' capacity to operate in these areas, as foreseen by international humanitarian law, and also to do so as is required in accordance with humanitarian principles. So what I plan to do is to first take us through the key elements of the international regulatory framework that is causing these tensions. I can give a few examples of how this international framework has been implemented international law. And then I'm going to touch on two other sources of restrictions, those in funding agreements, those imposed by the banking sector, interestingly. And then I want to look at the interplay between these counter-terrorism measures and IHL, international humanitarian law. And interestingly, that is one particular area that hasn't received that much attention in terms of the interplay between counterterrorism and IHL. And then just a couple of ideas as to how possibly to resolve these tensions. So if we start off with Security Council sanctions, the Security Council has imposed sanctions against non-state armed groups in a number of contexts, including in Somalia, the Democratic Republic of Congo, and the Central African Republic, and also cross-context against the Taliban, Al-Qaeda, and ISIS. Now, these sanctions require member states to impose a number of restrictions on entities that are designated, and including in particular relevance to humanitarian action and asset freeze. And there are two elements to the asset freeze. The first part requires states to freeze all the funds and other financial assets on their territory of designated entities. The second element requires states to ensure that no funds, financial assets, or resources are made available to designated entities or persons. And it is this second element of the asset freeze that is problematic for humanitarian action. As I said earlier, the risk exists that this obligation to prevent funds, material support from reaching designated entities will be interpreted as also including payments that are necessary in order to conduct humanitarian relief operations, such as the various tolls and taxes levied by groups that control the territory where civilians in need find themselves. It could also cover any relief goods that are diverted by these groups. Just to give you an example, under the Al-Qaeda sanctions, there are currently 75 entities that are listed, including the Al-Nusra Front for the People of the Levant and Al-Qaeda in Iraq, both groups that control territory in Syria and Iraq. Now, I don't know how closely you followed the discussions a couple of years ago about the whole authorization of cross-border relief operations into Syria, and the fact that the Security Council, exceptionally for the first time, actually imposed these operations. Great. There wasn't any joined-up thinking going on. So while on the first hand you had this unprecedented imposition of relief operations by the Security Council, the territories where the relief operations had to be conducted was actually controlled by designated entities, and therefore the risk existed that assistance provided or any payments made would fall within the scope of the asset freeze. So on the one hand you authorize it, and on the other, you're actually criminalizing any potential diversion of funds. This doesn't make sense. At the moment, obviously, one way of avoiding this tension would be to include a humanitarian exemption in the sanctions, saying assets must not reach these designated entities unless it is in the course of humanitarian relief operations. And that's in fact what we find only in one sanctions regime, which is the one of Somalia. It wasn't there originally when the sanctions regime was established, but at the time of the famine in 2010, 2011, under pressure, following pressure from the public and also humanitarian actors who said the reality is we cannot operate because in order for us to do so, we would probably fall foul of the asset freeze and the sanctions. An exemption was introduced, providing that the asset freeze shall not apply to the payment of funds, other financial assets or economic resources necessary to ensure the timely delivery of urgently needed humanitarian assistance in Somalia. So there is a possibility of somehow carving out humanitarian assistance from the scope of these asset freezes, but the reality is that in situations of armed conflict, the Security Council has only done that once in relation to Somalia. There is another exemption in relation to North Korea, interestingly, a situation not of armed conflict, nor a concern in terms of counter-terrorism, but where humanitarian needs are extremely severe. So despite the existence of a very broad prohibition on delivering a wide range of materials, there is a humanitarian exemption. And so far, the measures I've talked about are country-specific or party-specific, in the case of Taliban and Al-Qaeda sanctions. As you know, there are also counter-terrorism sanctions that the Security Council has adopted, most notably under Security Council Resolution 1373. This requires states to adopt a broad range of measures to prevent and suppress the financing of terrorist acts, including by criminalizing the willful provision or collection by any means of funds with the intention that they be used to carry out terrorist acts, so fundraising, and also prohibiting their nationals from making economic resources or any services available directly or indirectly for the benefit of people who commit acts of terrorism. So essentially very similar to the assets freeze that we've seen in country-specific resolutions. It's left to states to determine what entities are designated under this very broad resolution. And there are no exemptions for humanitarian activities. And for the most part, in implementing this resolution, states have also not adopted a humanitarian exemption. Another important source of limitations, specifically in relation to counterterrorism, are the Counter-Terrorism Conventions, the 19 sectoral conventions. And of particular relevance is the 1999 International Convention for the Suppression of Financing of Terrorism. And we find a very similar prohibition, which is requiring states to make it an offence to provide or collect funds by any means with the intention that they should be used, or in the knowledge that they're going to be used to carry out an act of terrorism. So a very broad prohibition that can impact the capacities of humanitarian actors to fundraise and also to operate. However, the convention itself does not include any exemptions to cover humanitarian action, but the mental element required to commit an offence is high. The person must have provided or collected the funds with the intention or knowledge that they be used to commit an act of terrorism. So that makes it unlikely that funds collected by humanitarian actors or funds or other forms of material support that humanitarian actors have to provide in order to operate would be caught by it, because it's not done with the intentional knowledge that they would be used to commit an act of terrorism. States have a considerable margin of discretion in how to implement these sanctions. This inevitably gives rise to a lack of consistency. The Security Council resolutions are just a baseline. In giving effect to them at national levels, states can develop them, for example, by adding designated entities, or also impose additional autonomous sanctions. For example, this has happened in relation to Syria, where a number of states, as well as the EU, have also imposed sanctions, despite the Security Council being unable to reach agreement on this. Domestic implementing legislation of sanctions should include any exemptions that exist at the Security Council level. As we've seen, that's only in the case of Somalia, and even that hasn't necessarily been adopted by all the states when actually giving effect to the sanctions at national level. So it's just an example of their capacity to adopt even more restrictive measures. This said, there is a possibility under most mechanisms, national mechanisms, to obtain licenses. So this authorizes the applicants to carry out activities that would be otherwise be prohibited. So either they can, sticking to what's relevant here, essentially it would allow them to carry out operations, even though these would entail providing unauthorized support to a designated group. So there is a mechanism to allow them to escape the constraints. But the reality is that it is very difficult as a matter of practice to obtain licenses. The procedures for doing so across states vary, but they tend to be fairly onerous and time-consuming, and as we were carrying out the research for this paper, rather opaque. So you don't really know who else is applying for a license, unless we happen to know that another organization is, and there's no way of knowing what the grounds are for its authorization or rejection. So while in theory it could serve the ultimate purpose of allowing you not to fall foul of the legislation, it is a very complicated way to get there. Definitely exemptions would be a far simpler approach. In terms of the mental element required to violate sanctions, it's usually a strict liability offense. It's not that you need to intend or have the knowledge that your material support would assist a designated group. It's just sufficient that in practice it does so. So this is quite problematic for humanitarian actors. It's very, it's a very broad basis for liability. And what aggravates the situation further is that states frequently grant their courts extraterritorial jurisdiction in relation to these crimes. So it can occur, it can be both conduct carried out by its nationals in terms of individuals and corporations, but also occasionally by third country nationals who might face liability in relation to activities carried out abroad if they find themselves in a state that exercises extraterritorial jurisdiction. In implementing their obligations under counter-terrorism obligations, states have adopted an equally broad range of measures. I won't bore you with the details right now. We can go into it. Some states have taken a narrower focus and taken the approach in the Terrorist Financing Convention and only criminalized the provision of resources with the knowledge or intent that it will be used to commit an act of terrorism, so less likely to be problematic. In some other contexts, what's criminalized is the knowledge that it will provide support to a terrorist group more generally, and that is more likely to be problematic because the scope of activities that could provide support to a terrorist group is far greater. Exceptions are extremely rare in national legislation. In Australia, the Australian Criminal Code does include an exception to the offence of associating with terrorist organisations, where this is done only for the purpose of providing aid. This is really more or less the sole example we found. Interestingly, in order to implement its obligations under the Security Council Foreign Terrorist Fighters resolution, Australia established a second terrorism-related offence, which is entering or remaining in a declared area. That is an area that the Foreign Minister has declared as one where a listed foreign entity is engaging in hostile activities. For example, the provinces of Nineveh in Iraq and Al-Raqqa in Syria have been designated in this way. However, there is an exception if a person enters or remains in the area solely for legitimate purposes, including for providing aid of a humanitarian nature. So exemptions such as this at national level would resolve the problem, but as I've said, they are really few and far between. And again, in relation to counter-terrorism offences, a very broad extraterritorial scope of application of the offences. So this international framework makes it extremely difficult for humanitarians to figure out exactly what they can do and when. As we've seen, the way it is being implemented at national level is by no means uniform. States have occasionally broadened the scope of the offences or designated additional groups. So support that a group that may be permissible under the laws of one state is in fact criminal under the laws of the other. And as we've seen, states may exercise extraterritorial jurisdiction, which makes it necessary for humanitarian organizations to be aware of the approach adopted by a number of states. Now, the reality is that the prosecutions have actually been very few in practice, but this is not the end of the problem, because the risk of these prosecutions has in fact significantly impacted humanitarians' capacity to operate, the transparency with which they do so, in terms even among themselves of sharing information, because they are worried about exposing themselves. And it's also raised problems in terms of fundraising, because it raises concerns about funds being used in an appropriate manner. So it's actually an extremely complex legal landscape that NGOs and humanitarian activists have to navigate. The bigger organizations have the capacity to figure it out. It's much more challenging for the smaller ones. Now, everything I've said so far is not really new. It's something that humanitarian activists, as I've said, have definitely had their eye on for a number of years. The challenge in getting things changed lies in establishing the impact of these measures on operations. It's very difficult. It's frequently been described as a chilling effect, and that's just not a very useful way to. It's not very compelling if you're trying to engage with the state or the Security Council to encourage them to adopt an exemption, to say it's had a chilling effect on our operations. But it's difficult to obtain empirical evidence of the extent of the extent of the impact. Interestingly, though, it's the effect of the impact. It's a secondary effect of these restrictive measures that is having the most significant impact. Prosecutions have been very few and far between. But it's not just humanitarian actors that need to comply with these measures. Others do as well, and most notably the banking sector, because they're also bound by sanctions, by counter-terrorism measures. They have the same obligations not to ensure that funds don't reach designated entities. That, combined with the reality that most humanitarian actors are just not high-profit clients, have led to the banking sector, and at the moment it is principally the UK banking sector that's being researched, to adopt a significant number of restriction on the access to financial services of NGOs. They have closed the accounts of a number of NGOs operating in problematic contexts. They have imposed very significant additional charges. So one story that I have heard anecdotally relates to the UN that is trying to transfer funds to operate in a delicate country. I don't know what it is, but I assume it's one where a designated entity is operating, and it could not find a bank that was willing to carry out this transfer. When eventually it did find one, it charged the UN 30% fees in order to effect the transfer. This is quite a compelling figure. So interestingly, I think we've all had our eye on the wrong ball because we were focusing on the risk of prosecution's back-chilling effect. Very practically and immediately for a whole range of actors, it has been the restrictions adopted by the banking sector that have had the most immediate impact in terms of fees, in terms of delays in receiving funds, transferring funds, in terms of closure of assets. So in terms of actually trying to change the system, one way of showing the impact is going to be, let's try and quantify the extent to which the restrictions imposed by the banking sector in order to itself comply with these regulations is affecting humanitarians' capacity to operate. Another source of significant restrictions are the clauses in donors' funding agreements that they don't actually preclude humanitarians from carrying out activities, but they tend to require them to adopt due diligence or measures to ensure that none of the assistance reaches designated entities. We can discuss them in detail later. There are a range of measures, some fairly understandable, exercise due diligence, others significantly more intrusive, and particularly those of the US that essentially require recipients of aid to vet partners and recipients down to beneficiary level, and lists of names to be provided to the US to be checked against a database. And if we look at these funding agreements, obviously donors' desire and indeed obligation to exercise some oversight to ensure the funding does not support designated entities is understandable, but the inclusion of these funding provisions has raised a number of concerns for humanitarian actors. First, practically, complying with the associated reporting requirements and other requirements is administrative onerous in terms of time and resources, particularly for small NGOs. Secondly, some of the more intrusive measures, such as the vetting, but also obligations that's frequently found to notify donors if they know, if recipients become aware of any association with designated entities, may give the impression that humanitarians are gathering intelligence for states. And more generally, they can be perceived as having co-opted humanitarian actors into donor states' counter-terrorism strategies. And this is likely to have an adverse impact on how humanitarian actors are perceived in the context where they're operating, and it's likely to be all the more problematic if the donors are in fact parties to the conflict in that particular state. And finally, and perhaps most problematic, these measures can in fact prevent humanitarian actors from operating in a principled manner, responding to people most in need first. If the only way to respond, if responding to people in need would require them to engage with associated entities, the risk exists that humanitarians will stop doing so just because they don't want to fall foul of these restrictions and funding agreements, which means that they're not able to provide assistance to people who may be most in need. So different, because obviously states can decide who to fund, but equally problematic from the point of view of humanitarian actors and people in need. Now, the final point I want to touch upon is the interplay of these measures with international humanitarian law specifically. And it's actually not as straightforward as we think it might be. And I think that there's three areas that we need to look at. First, the entitlement of humanitarian actors to offer their services to parties to an armed conflict. Secondly, the rules regulating humanitarian relief operations. And finally, the rules protecting the wounded and sick and those providing humanitarian assistance. Because these are the three areas where the interplay is most complex. In terms of offers of services, Common Article 3.2 of the Geneva Conventions establishes the entitlement of impartial humanitarian bodies to offer their services to parties to armed conflict, either sides, including in non-international armed conflicts. And these may include non-state armed groups that are designated under sanctioned regimes or counter-terrorism legislations. Any measures that would criminalize offer of services would in fact be incompatible with this entitlement to offer under Common Article 3. However, very few of the existing measures actually go this far. None of the Security Council resolutions or the Counter-Terrorism Conventions preclude humanitarians from offering services. At the national level, while Australia's crime of associating with terrorist organisations would appear to preclude making of offers, that is the one example where we actually have the exception, which allows the association if it is only for the purpose of providing aid of a humanitarian nature. One of the measures that some states have adopted in their funding agreements are no contact policies. Now, although we've heard a lot about these so-called no contact policies, from what I understand at present, they only exist in relation to Hamas in Gaza. That's the only instance where there is actually a no contact policy. And if you look at it, despite its broad name, it doesn't actually preclude all contact. It accepts that it might be necessary and says that this is when it is necessary in order to carry out relief operations, it needs to just take place at a technical and lower level. So even that particular instance would not, in fact, amount to a prohibition to offer services. Now, if we look at the rules regulating humanitarian relief operations, things become more complex. Offers of services are just the first step in actually conducting humanitarian relief operations. If the party with control of the civilians is unable or unwilling to meet their needs, IHL provides that offers to conduct relief operations may be made. The consent of affected states is required, but may not be arbitrarily withheld. And once it's been obtained, parties must allow and facilitate the rapid and unimpeded passage of relief operations. Now, tensions are likely to arise between these rules and restrictions in sanctions and counter-terrorism measures, where we have designated entities in control of a group of territory and civilians. And I think the precise interplay depends on who the state is imposing the restrictions. Now, if we're looking at the state party to the armed conflict, its consent is required not to be arbitrarily withheld. I actually think that withholding consent merely because the party in control of the territory is a designated group would be arbitrary. Why? If the civilian population is facing starvation, withholding consent would be a violation of the prohibition on starvation of the civilian population. If we are withholding consent to medical relief supplies, it would violate the entitlement of the wounded and sick including fighters, members of the armed forces and of the designated groups. And more generally, it could violate the prohibition on discrimination or could be considered a form of collective punishment. So withholding consent would be arbitrary. So states are not entitled to withhold consent, but they are entitled to prescribe technical arrangements for the passage of such relief operations, including, for example, requiring humanitarian actors to adopt measures to ensure the relief goods are not diverted from the intended beneficiaries. However, absent a humanitarian exemption, humanitarian relief operations that have been authorized might still be incompatible with the sanctions and counter-terrorism measures of that states, because they're two different bodies of law essentially regulating the same activity, which means that the consent would essentially be meaningless because the organization and its staff would still face the risk of liability under national law of that state. So here is an area of tension between IHL and counterterrorism measures. The tension is even more stark in relation to third states. So, for example, a donor state or another state that is exercising extraterritorial jurisdiction in terms of its counterterrorism measures. You might find yourself in a situation where the state party to the conflict has authorized the relief operations. They're being carried out, but they might still fall foul of the sanctions and counterterrorism legislation of some third state. So clearly a tension between activities that are legitimate and being conducted in accordance with IHL and counterterrorism obligations. And perhaps the last example I'll touch upon now, and it's the most stark perhaps, is the whole question of the protection of the wounded and sick. It's a foundational principle of IHL that the wounded and sick, civilians and fighters, are entitled to receive the medical care required by their condition. And medical reasons are the only permissible basis for treating the wounded and sick differently. And equally foundational is the corollary of this protection, which says that those providing medical assistance to the wounded and sick against civilians or fighters may not be harmed, harassed, prosecuted in any way for having provided this medical assistance. In recent conflicts, however, we've seen a repeated violation of these protections, perhaps most evidently by the attacks against medical facilities, but more perfidiously, perhaps, are less evident measures that suggest a rejection of these foundational principles, at least when medical care is provided or in other way connected to non-state armed groups that have been designated as terrorists. And the measures have taken two principal forms: denial of access to medical relief operations and criminalization of provision of medical care to members of designated groups. So in terms of the first, I think Syria is the most documented examples. Parties to the armed conflict have refused to allow the passage of medical relief supplies because they can be used to treat wounded enemy civilians. Clearly a violation of the principles of IHL, all the more so because the same medical supplies are likely to also treat the wounded and sick civilians. I think what's interesting and equally troubling, and it links in with counterterrorism, are the number of instances where people providing medical assistance have been criminalized. This has occurred in a number of ways. And at the international level, while the provision of medical assistance is not per se a basis for being listed under the Security Council, ISIL, and Al-Qaeda sanctions, on two occasions, the Sanctions Committee has identified the provision of medical care to designated groups as a basis for listing specific individuals. This suggests that the Sanctions Committee considers the provision of medical care a prohibited form of assistance to Al-Qaeda, even though this is expressly foreseen and protected by IHL. And unfortunately, the same designations have been carried down to national level. Also at the national level, there's been a small number of prosecutions for having provided medical assistance to members of designated groups. In the US, but not just. Two examples in the US are particularly striking. A doctor was convicted for attempting to provide medical care to wounded members of Al Qaeda, which was considered a form of criminal material support. And even more exorbitantly, I'm going to have to read this because there was a prosecution where the defendant was found guilty of providing material support to Al Qaeda in the form of prohibited training by having assisted nurses who treated Al Qaeda fighters to read the English language labels on medicines. So helping them read the English language labels on medicines amounted to a prohibited and therefore criminal form of material support. This is how far we've gone. And I think there is concern that in implementing their obligations under the foreign terrorist fighters resolutions, states might also include in their definition of what amounts to being a foreign terrorist fighter, persons traveling abroad to provide medical care to wounded and sick members of the armed forces. No prosecutions have in fact taken place, but the issue arose in the UK in relation to a number of students. So very, very troubling in terms of the interplay with these very foundational principles of IHL. How do we go forward? Well, I think, as I've repeatedly hinted, the simplest and most clear-cut way of doing this would be by means of humanitarian exemptions in the Security Council, sanctions, in the way they're given effect to at national level, in the counter-terrorism measures. We've only had two so far. There must be a reason for this. States are unwilling to go there. Licenses is also an option, but as I've said, far more cumbersome. But it might be that we should try and develop guidelines to make licenses more accessible and easier to obtain. On their sides, humanitarian actors have got to enhance the measures they take to avoid the risk of diversion. It's likely to be something that's going to be demanded in any humanitarian exemption that's developed. Obviously, avoiding the risk of diversion is something humanitarians do on a daily basis as part of their operations, but there is a great difference of approach among organizations. So it's incumbent upon us humanitarians to share best practices. Finally, the banking sector. And I smile at that because it still catches me by surprise. It's going to take time. Hopefully exemptions and these anti-diversion measures are going to have an effect in alleviating their concerns, at least about the risk. They're still like humanitarian actors are still likely to be very low profit. So that's not going to change. It's going to take time, and I think that it's going to be, that's just a very different challenge. It's going to take different parts of governments, for example, the Treasury to get involved, the FATF, financial narrative, but it shows how humanitarians are only now getting used to this. The Financial Action Task Force, intergovernmental body that provides guidance to the banking sector, plays an important role in this respect, so incumbent upon us to impress upon them the need to find a way of resolving this issue.
Start? I'll go for it. Well, the one thing that I want to go back to the beginning of the presentation, and I've been working on issues of presentation in previous years, and I know that, for example, in Israel, there is a process of designation terrorist organizations in line with Security Council resolutions, and we've moved from a process of internally look into each and every organization designated to automatic designation of their own, almost automatic designation from the Security Council. I know that in Europe they've mainly done the opposite point, and I wonder if you know about the process going on for designation of these organizations, which has so many implications. So, what is the designation process in the UN? It's based on taking into account the numerous effects that you described.
Yes, and that's, shall I answer?
That's all.
Yeah, let's start with this one. And that's a very good question. I'm not too sure, so when you say automatically, whatever the Security Council does. And this opens up a rather different can of worms about the interplay between sanctions, counterterrorism measures, and human rights more broadly. Talking about, exactly, talking about the human rights of designated individuals rather than entities. But this is a big issue in terms of rule of law and oversight of the designations. Now, from what I understand, there's a difference as to how the Security Council does it. For most contexts, it is actually pretty straightforward. Security Council members propose the designation of a particular entity, or far more problematically, individual, and unless there is a complaint with that by members of the Security Council within a specified period of time, that person is listed. End of story. There is no due process at all. And as you say, a number of states have the obligation, once these entities are listed by the Security Council, states have the obligations to impose the restrictions on them. So essentially, yes, automatic designation as well. Now, I'm not an expert on this, I'm educating myself as well. This has raised problems and challenges before the European Court of Justice and also of human rights, because some of the individuals, we're not really the groups that I've been discussing, but some of the individuals said, hold on, designation has really significant effects on my rights, it subjects me to an asset freeze, it's got very significant, it's not the same as investigation, but it curtails my rights in many ways. I'm subject to this without any degree of due process. And this challenge arose in relation to, I want to say, Taliban, Al-Qaeda. They were a single sanctions regime at the time. It arose in relation to that. And in response to this challenge, a system, an ombudsperson was established in New York within the sanctions framework that would actually receive complaints of designation. But paradoxically, because exactly the same problems arise across all sanctions regimes, this system that perceives the possibility for individuals to challenge their designation only exists in relation to the Taliban, Al-Qaeda, now ISIL sanctions, not in relation to the others. So that's at the Security Council. Therefore, all the others can't be challenged, and it therefore means that at national level they cannot be challenged. The position is different in relation to unilateral sanctions or those established by the EU, because there is a possibility to challenge the system. It's a separate conversation, but we're finding ourselves in a situation where you have essentially the Court of Justice challenging the decision taken by the Security Council. How does that work out in practice? Very interesting.
I'm trying. Something that bothers me. Usually the problem, you say that many countries will not go along. I don't know many Western countries not wanting to go along with humanitarian relief, etc. So there's something wrong here. I'm trying to understand what bothers these countries. And what jumps to my mind is that terror is the definition of terror. Okay, so if we are dealing with Islamic terrorist group, we see that they have it's a way of living. Way of living. It's not just the terrorist act. There's a whole complex issue which they call dawah. It's a humanitarian relief that you can call it as a humanitarian support that they give to the population in order to win their hearts and minds. So, and one of the things that countries try to do, and Israel does, is to cut this curve of support. And this is very close already to the humanitarian relief, the actual humanitarian relief that the organizations, international organizations, NGOs are trying to give. So the separation may be a bit of difficulty here. Now, am I right? Is it part of the question and a part of the problem? And it would really help me if you give an example for that, for the issue here in Israel, where I can put it into context, maybe try to figure out a bit more about the core problems that you're dealing with.
No, and it's a very good question. And in a way, when we try to frame this problem, you start off with the same reaction to say, something's bothering me. States tend to be honest when they say that they want to provide humanitarian relief to civilians in need. But I think the challenge arises when these civilians find themselves under the control of terrorist groups that are bad. And I think part of the problem goes back to what we were saying earlier about labeling and the increasing tendency I find to label at international level, domestically, but to label any organized armed group involved in a non-international conflict as terrorists. We're looking at non-international conflict through the prism of terrorism, and that already changes the dynamics and how states look at it. All the more so if you imagine, hold on, those situations where, in fact, a terrorist group that is controlling territory has attacked them. I'm thinking now here of the various ISIL factions. Then, how do states reconcile their desire to provide assistance to civilians who are clearly in need with the reality that the risk exists that some of this humanitarian assistance might be diverted to the terrorist groups? That is, let's go back to Sweden. Let's assume they don't have any ulterior motives. I mean, and that's a nice assumption, because the reality is that development aid, humanitarian aid, is all too frequently part of your policy more generally, foreign policy more generally. Let's forget that. It's a question of how to reconcile it. And it is challenging. And I suppose some states, some donors, see this reality and say, well, the fact is that in certain contexts, it is inevitable that some of the humanitarian assistance is going to be diverted to these groups. It's just inevitable. It's inevitable. We're responsible for it. We've accepted bad practices of paying at checkpoints. It's inevitable. Some donors say it's inevitable, let's take measures to minimize it. Others are not willing to go there. I think you raised a very good question about the reality that in some contexts, where these organized armed groups are effectively administering a territory, it's actually difficult to draw separation from their fighting wing, their fighting activities, and their humanitarian activities. And this is
furthermore, the country that tries to fight these organizations, trying to take their support, the public support, the indigenous population in the public support in these implementations. And the way to do that is to withhold them the ability to govern them, to give them to give or to welfare and to any other pay salaries and etc.
exactly.
So the question would be, why can't NGOs keep the money for themselves? This way, not paying the money, not transferring the money, having systems that they are not transferring money into this group. This is more, seems to me, the practical solution to the problem, because otherwise you always step on the sort of attention that you have here.
Absolutely, it's the anti-diversion policies. So you've got extreme context. Somalia, because everyone's aware of it, where you have to pay to cross the checkpoints. In others, it's more a question of diversion of funds. I mean, there's been the case of World Vision here, hasn't there, of alleged diversion of funds, very extreme if you want, but alleged diversion of funds. Another element that arises in contexts where these designated groups are administering territories is they might be meeting the needs of civilians. If humanitarian actors start carrying out relief operations there, even without questions of diversions, essentially it means that the funds that particular group was using to meet the needs of civilians have been freed up and can be used for other purposes, including terrorist activities. And it's interesting to see the approach adopted by different courts of different states. This is called fungibility in the US, I've just learnt it, which means that if you're providing funds, you cannot determine how they're going to be used. Essentially, if the risk is that they're going to be used in any way to support terrorism, including because they free up money that would be otherwise used to meet the needs of civilians, it would fall foul of the legislation. They've adopted a very, very broad approach to.
Very problematic.
It's
against our child.
Yes.
That's the reasons that we said before.
Absolutely. So essentially,
so it's okay to not to give your terrorist group the funds that makes them what they are, the ability to control the population, the ability to. It's a good case for that. Not having other NGOs going in and giving the right itself, that's a violation.
Exactly, because that would be problematic, the way it's interpreting it so broadly.
Yeah.
Fund the provision of carrying out activities, which essentially would mean freeing up the funds, would still fall foul of the legislation. So that's the approach adopted by the US courts, not just in one case where it was determined what material support was. Interestingly, diametrically opposed decision, even though they don't use the word fungibility, in the European Court of Human Rights, where the question was whether social security payments made to the spouse of a designated entity could somehow amount to prohibited support, because they would mean that that person would no longer have to pay for his food and accommodation, and therefore could use that money to carry out terrorist activities, was not accepted. They don't use the term fungibility. There was also a degree of de minimis, saying, come on, it's social security payments, what are you going to do with them? But still, it shows that there's a divergence of approaches between the US courts and the approach likely to be adopted by the European Court of Justice. I mean, the problem here is that different states have adopted very significantly different approaches, and humanitarians don't really know where they stand. This comes to mind to me when I'm thinking of this social security payment decision, because the court could not actually look at the actual terms of the relevant regulation, because it discovered that it had been, key elements thereof had been translated in diametrically opposed ways into the national legislation of the EU member states. And we're striving to achieve uniformity. You've got an EU measure that has been translated in different ways in domestic law without even looking at its implementation. But that gives you an idea of the complexities of the legal framework that we're up against. But like you, I share the initial, I have the same initial degree of discomfort. In persuading states, you just have to take different angles depending on who you're speaking. Some need to be persuaded that there is no risk of diversion of anything.
Yeah.
Others are more comfortable with humanitarians taking risk minimization measures.
I have a few questions. First, you mentioned the Counter-Terrorism Convention, which sets a very high mental alert. As we said, they know that the intention is to, and it seems like a very long way from this to what is actually happening. Like you said, that even medical aid nowadays sometimes can be forbidden. So what happened in between? I guess maybe I missed something. And secondly, what are your suggestions for exemptions? And thirdly, well, even if you do set some exemptions to aid that you can provide, only if all the countries will follow and apply to it, it will be really practical, because otherwise funders can just set up in a different country and just give funds to countries which don't forbid those kind of aid and relief to persons in need. So how can we deal with that?
What happened in between? Very good question. The example I gave is the Convention on the Financing of the Convention for the Suppression of Financing of Terrorism, which requires the knowledge that may be used in full or in part in order to carry out an act of terrorism. Very high level of intention. A number of states, in establishing their own national counter-terrorism legislation framework, have adopted exactly this approach. So it's fine. But of course, nothing precludes them from going more broadly. This is just a minimum standard. So, and that's what's happened in a number of contexts. Some have prohibited assistance that is likely to support a group. This goes back to the conversation we just had. That's incredibly broad. Any support to the group would be criminal and would fall within this. Others still, like the US, have gone it even more broadly, and it was in the US that I gave the examples of what amounts to material support. It's very difficult to understand why they've gone so broadly. So initially there was, just to give you an example, in the US legislation, initially there was an exemption for the provision of medical services. Let's just focus on that. That was narrowed down following the something purely internal to the provision of medicines. So you've got this paradoxical situation where providing medicines is not prohibited, but providing the assistance, helping people read the labels in English of those medicines is prohibited. It makes no sense. I suppose, one of the realities, and it does kind of lead to your question about exemptions, is that this issue has only arisen fairly recently. That's in the past 15 years. It's come out very prominently. And I wonder whether we humanitarians have been sufficiently vocal and sufficiently united in highlighting how problematic it is. And I don't think we have, for a number of reasons, and that ties to the impact. Just sometimes, because the reality is that there are some organizations that are more effective than others. If you look at what states say in their funding agreements, they have different provisions for the UN, the ICRC, and some little NGOs. Why? Because they trust the UN and the ICRC more to take appropriate measures to avoid diversion than the little NGOs. What does that mean in practice, though? My camera's on. It means that when humanitarians try to take a joint position to raise these concerns, the big organizations might actually say, it's not so much of an issue for me, I'm not going to upset my big donor. And we're seeing this in relation to funding agreements, rather than the legislation itself. Changing legislation is a challenge. Imagine having to persuade Congress that they need to change the legislation. But you need to do it in parallel. Suggestions for the exemptions. Interestingly, again, it's a question of making the case for the need for them. There's been a considerable push at UN level, at the GA, where there is periodic adoption of the global counter-terrorism. I'm going to get it wrong. I'll try to get the precise term right. There's a GA resolution on the UN global counter-terrorism strategy, and it was recently adopted. And after much pressure led by the Swiss, among others, for it to address exemptions across the board, so not just in sanctions, but across the board. We've come up with this paragraph 22, where the GA urges states to ensure, in accordance with their obligations under international law and national regulations, that whenever IHL is applicable, counter-terrorism legislations and measures do not impede humanitarian and medical activities or engagement with all relevant actors as foreseen by IHL. So it's the beginning. It's a recognition at GA level of this problem. Systematic inclusion of exemption clauses in Security Council resolutions. There was a huge review of sanctions for the past couple of years. I don't know whether you followed. This was an issue, but it just didn't pick up sufficient traction. Why? Within the UN system, which is where I used to work, the humanitarians have been described as the lower reaches of the organization. I think that's a bit the reality. I was the representative on the Counter-Terrorism Implementation Task Force that brought together all the members of the UN dealing with counter-terrorism. It was very difficult to have our say and flag this issue. It was just not important. And even among humanitarians, even if we get beyond all of that and look at humanitarians, there's no unanimity as to the value of exemptions. It was something that came up in a paper that was recently published by Harvard. Some humanitarians are wary about the inclusion of exemptions because they say, well, what about the other contexts where we don't have an exemption? We're worried that it might be read at contrario as saying, well, you've got an exemption here, you don't have it in this particular instrument, therefore it means that humanitarian activities are not, in fact, exempted. So a lot of challenges to overcome at various different levels. I have to say, at the moment, I think simply the best entry point might be the EU, because for a number of levels, they have a number of exemptions already, which is positive. It has a reverberating effect because all the member states need to implement them at their national level. If somehow this can be shown as being workable, and now is when I start getting a bit skeptical, it could be that it could influence the Security Council. It could be. I mean, they're very different cases.
I have a clarification question. I was trying to read between the lines of your argument whether or not you are of the opinion that we need an international agreed definition of what is terror, let's say. You gave the example of the convention, and it's a very convenient example. And on the one hand, it seems that the root of the problem is the lack of clear consensus, and on the other, it's practically rather convenient because it allows states to work around it. So I remember that in 2011, when the STL came out with its definition, with the definition of terror, it was such a wow moment in PIL, and it was left to one side. It seemed that no one really adhered to that, and so I wonder, maybe, what is your opinion on this? Maybe this is a situation that Anne-Marie Slaughter called the future of international law, domestic law, sort of. Because indeed it seems that domestic legal systems seem to be more advancing the international law at this point. Maybe it's not something that, let's say, the IOC should add to its program. And the second question being, when you mentioned the example of helping with the medicine, it caught me off guard. I literally have never heard of that. And my initial reaction was shock. And then I asked myself, well, what is the difference between that and, let's say, suicide and prostitution? A lot of criminal domestic systems do not prohibit prostitution per se, but do prohibit solicitation of prostitution. They do not prohibit the act of suicide. They prohibit helping someone to end his or her life. So, insofar as we think about it this way, what are we doing to terror if acts in and of itself is not necessarily prohibited under a certain instrument, but helping someone reading the medicine or the labels would qualify as a wrongful act?
Both good questions. Definition of terrorism, I think, is not so much the problem in this particular problematic on this particular issue. I think it raises a significant number of problems in terms of the interplay with IHL, in terms particularly of acts that are visible under IHL. For example, attacking military objectives are frequently included in the definition of terrorism. Attacking members of the armed forces, attacking government facilities that might be military objectives might still fall foul this is, I think, one of the reasons why we still don't have that famous comprehensive convention against terrorism. I don't actually think it's a problem in relation to this particular question of humanitarian action. I think what the problem is, one is, to a degree, a tendency, as I said right at the outset, to look at every non-international armed conflict through the lens of terrorism, therefore it brings them in there. And one is quite simply just the interplay between the two bodies of law, which in a way takes me to your second question about medical assistance. And maybe I wasn't clear, or maybe you mean, so providing the drugs wasn't prohibited, but reading the labels. Yes. Yes. I mean, I think what's wrong there, I mean, reading the labels being prohibited is what's wrong there, is that essentially that particular state's legislation is criminalizing one of the key principles of IHL, which is the entitlement to provide medical assistance. That provision is a violation of IHL, so I'm not so sure it actually works with the analogy of assisted suicide. Or I don't think it quite works. I mean, that's the reality. Going back to your question, what more should we do? Well, maybe we should. I think in terms of going forward, it could be that now that there is a gathering momentum on this whole healthcare in danger range of issues, this could be an opportunity to start at least whittling away at the elements of this framework that are most problematic in terms of providing assistance to the medical wounded and sick members of our of designated groups. That said, again, a separate conversation, but we focus on the attacks on hospitals, yes we should, but the extent to which the entitlement to receive medical assistance, the entitlement to provide medical assistance has been whittled away at in many ways in the past years is really quite problematic, and I don't think something that's sufficiently come to the fore. I also think, I remember raising this in New York. My job was to bring Security Council members of key protection of civilian concerns ahead of the renewal of relevant Security Council resolutions. And I remember once in relation to Afghanistan, there were a number of problems in terms of interference in the provision of medical care. Didn't want to care. Didn't want to care. I mean, going back to why is it bothering me, the reality is that some states are really not bothered by something that's as problematic in terms of infringement of the foundational principle of IHL, entitlement to receive and give medical care. Some states are not that bothered about these more insidious interferences. MSF's very upset.
Any more comments, questions? Okay. Thank you very much.
Thank you.
Okay. We have about 50 minutes before we go to before we to be at the restaurant. Which includes Humanitarian. So slowly get on the way. Just need to see if we have enough cars over the past. We go. Yeah. That's an issue. Not a big deal.
We're going to eat.
Not a big deal. We're going to King George restaurant at
I have to be sure you're taking me to the right place, not something a terrorist organization.
I threatened Robert today
Yeah,
you threatened Robert.
Yes.
So you're not going
on
to
live camera.
on live camera.
No, it wasn't on that.
It wasn't.
Only that. With King George restaurant at Annecy Street.
I have a card with 3 places. Great.
I'm going to the hotel first.
Okay. I don't have a card. Okay, so I'm taking
Very much like the ride. I don't have a card. And I have no places.
You're
You want
welcome.
to put your stuff at the counter before you. There isn't. That was the whole point of saying we have to have like.
We can, and we're gonna see when Humanitarian 4 is, but maybe we can have a walk on the promenade and have a look to the hyperbay, which is really good.
Seven hours later.
Suitable.
Okay.
This coffee.
Filming.